Participant in this conference. Please announce yourself.
Yim.
Hi.
Hi, Sarah. All right, so I'm going to do a little work until they get on, okay, Sarah?
Huh?
I'm just going to work. I'm going to be on the computer until they get on, yeah? Because I have a little bit of work to do while this is going on.
Hi, this is Gigi.
Hi, Gigi.
Hi.
How are you?
Oh, you sound so far away, Sarah. Sorry, I'm not exactly at the phone just yet. Oh, okay. While we were waiting.
Yeah, I'm sorry. I'm going to have to step. Hi, Gigi. It's Yim. I have to step. I'm in my office. If you give me 1 second, so I'm just going to go off for 2 seconds. I just got to deal with something on my computer. 1 second.
Okay.
Facundo? Yeah, it's not. The camera's not picking up the charge on it. What do I do?
The what?
The camera's not charging.
Oh.
What do I do?
This is for
Is that on? Is it charging?
Yeah, no,
okay.
it is.
Okay, thanks, honey. All right, go back to. Can you just look at those files for me?
Yeah.
Thank you.
Hi.
Hi.
We're just, Yam's dealing with something. She'll be right back.
I just got back. My assistant fixed it for me, so I'm good.
Okay.
Thank you.
Okay. So, thank you for everyone getting on this call so quickly. So, Sarah, the reason why I said that this was time sensitive is because after speaking to both Susan and Alex, I guess since I am the chair and I make the final decision, feel like given the circumstances, which is what we wanted to preferably meet in person, have decided that we're going to temporarily suspend the L.E.S dwellers for 3 months as a officially recognized block association, and that actually applications that have been coming in for the past week or so, that we've been doing that already, and we wanted to tell you exactly kind of why we came to that conclusion and kind of hear your side of things and talk about sort of what, what can be done in the next 3 months so that you guys can be on track and come back and be working with us together, because it's I feel very strongly about your mission. The concerns really are, at this point, the way you do the work, the way that your message is coming across, not only to the larger community and how it affects the community board, but at this point, Dennis Rosen up at the FLA also has very serious concerns with kind of how you guys are doing your work, and that was really what played a huge role in why we came to this decision. So I want to get that part out of the way.
Is Alex joining this conversation? I'm sorry, Gigi. Is Alex on the phone too?
She's not, but I've spoken to her about this.
Mm-hmm.
So I can tell you a little bit about where she stands on this. I think all three of us are, and I'm aware, and since I'm assuming this is a safe place, I know that there has been some differences in opinion and approach between the way that you've been interacting with Susan in the office as opposed to Alex as chair of the committee. But at this point, there's just too many patterns that we're seeing that really trouble all three of us. And so we did come to this decision, all three of us as a whole together. So that's what I will say, is that that we all did discuss this prior to this call, and you should be happy to reach out to her, and she would be happy to speak to you about this, because she's at work and she couldn't make it, and then she's actually heading upstate to see her mom. But we wanted to tell you where we stand, and also what some of the concerns are that Commissioner Rosen has kind of articulated to Susan and myself.
Oh, can you elaborate on that, if you don't
Yeah,
mind?
Susan, why don't you?
Yeah, I spoke to him. First of all, this sort of became sort of an immediate seriousness when, right before the meeting, our last committee meeting, I had an applicant tell me at the very last minute that he was withdrawing from the agenda, and I said, "Why on earth are you doing this?" And he told me that the dwellers had sent him information, and he didn't take it as being, it seemed rather intimidating to him. And I said, "Why didn't you let me know about it?" He said, "Well, I assumed that you wanted us to work with them, and that's why they contacted us." And I said, "No, we never even put you in touch with them. Because the applicant was east of Essex." And I said, "We wouldn't even, their area doesn't even go that far, so I don't understand this, and I don't understand why you're withdrawing." And he sent me the resolution that you had sent to him, and I gotta admit, I was really surprised that someone was asked to withdraw from the CB3 agenda without CB3 being informed, and that they would be asked to withdraw in any way without at least consultation with us. And the resolution was pretty strong. And I sent it up to Dennis Rosen, and I said, "This is what's happening. I'm concerned about this." And I spoke to him, and it turned out evidently this has been going on more than just this one case. And then I saw a copy of a similar resolution in the paperwork from the committee meeting. It was, I guess, turned in at the committee meeting. So I don't know how much this is going on. You guys aren't working with us, so I don't really know what's going on, but it turns out some lawyers have complained to the SLA about this. I guess their clients are complaining to them. And you guys do important, valuable, excellent work, but the strategy, unfortunately, is not making it effective. And, I did mention to Dennis, I said, I want to make sure we're all on the same page, and that you had announced a couple of things at meetings about the SLA. And one was that you were told that you could submit material on your own, and that even though the community board had said we don't accept online petitions, you had been told by the SLA that it was okay. And he urged me, in an email, he urged me to try and find out from you who at the SLA said this. He is also trying to find out. So as far as the online petition, they certainly don't encourage it. He didn't say they wouldn't accept it. He said they certainly don't encourage it. But he is concerned about the message getting out, because I don't know what numbers you're calling and who you're talking to, and he wants to make sure they're all on the same page. So at one point I emailed, I think Sarah, I'm not sure if it was both of you, asking, who it was. I never heard an answer. So
no, that was me. I'll gladly forward you. It was Kelly O'Brien, I believe, but I'll send it to you.
Carrie, oh yeah, that would really appreciate that, because they need to all be on the same page. This stuff ordinarily doesn't come up, but because it's becoming such a volume and such a big deal now, it is coming up. And the other thing Dennis said, and he said, when he said this, I said, "Can I say you said this?" He doesn't, they take, well, just to back up a little bit, the law is that the SLA is mandated to work with the community board or consult with the community board in 500-foot hearings. that's it. They don't have to talk to us about their wine. Applicants are required to send us a 30-day notice. They're not required to come to meetings or anything else. Everything else is just at the discretion of the chair, and applicants know that the chair is not going to look favorably, on applications if they don't work with the community board and meet with the public. He has always encouraged that. And they've always taken information from the public. But what's happening now is his words were like a shadow community board, and he said that you must submit material through the community board.
Okay, I just want to be very clear. So I just want to make sure we understand this clearly, Susan, and I thank you for explaining it. From the state authority, from Dennis Rosen, said that we must submit all of our material through the community board, not directly to the SLA. Is that correct, is what you're saying?
He did say that.
Okay.
And I said specifically, can I quote you? And now, just to go back, we didn't talk about what materials and what not materials, so I am sure, for instance, there are complaint forms on the SLA, which are certainly, everybody's encouraged to fill out complaint forms if there is something. I think he's talking about the volume of materials, not just, this place is doing this. I did not clarify him. But what's happening is basically you guys have been bypassing the community board, and therefore he's like dealing with two community boards. And he did not go in, this was not a long, specific conversation about this aspect. So, I'm assuming, why this is, why he said that is for a couple of reasons. I assume the amount of work is one. I also assume that, you hear ALJs all the time saying we're mandated to consult with the community board and no one else, and they do, but it's kind of a courtesy that they do that.
Okay, thank you for your explanation. So let's go back.
And to be honest, we can't do, you guys do amazing work. We can't do our work properly if we're not working together.
So I just, to speak to that, I would like to, I think it's a perfect opportunity to speak to that. And so in regards to the DL, I just want to understand procedure. When you knew, and the community board has learned of the DL's, let's say, questionable operations, such as open bars and dancing and things that you did acknowledge that you were aware of. Now, what is the procedure for you to report that to the SLA, or is it for, I'm trying to understand, where does that information go from the community board?
So, I'm going to say not every case is the same. It depends to some extent how the owners are willing to work with us and everything. The other thing that's an issue for me, it's really, really important to me that, like when I say anything to the community or to a business or to the SLA, that I be very fair to stick by my word. So when the complaints came up, I think they were just about a year ago, that we were kind of sort of intensely talking about them with the DL, and I didn't go into looking at each one of them because I said, I have Paul an email because he represents people and all that, and I said, I have complaints about your place. He said, I will meet with them. I said, fine. I said, do you guys agree to meet with them? So I did nothing after that except for follow-up, because the next step was to meet and see what could be resolved. For instance, 199 Bowery, residents told me there was dancing there. They hadn't applied for their cabaret permit yet. I said to them, stop the dancing. And there was no more dancing. That was the end of it. So in this case, the next resolution, the next step was for you to meet with DL. I followed up with you a couple of times. I know you and Paul emailed, I think, between October and March. There were emails, we need to meet, we need to meet, we need to meet. You said you were too busy with 106 Rivington, because I kind of reviewed all this stuff. And I said, I understand that, and I understand it's a priority, but I said to you in writing, I cannot follow up until we complete this next step.
I guess that's not really my question.
The business has offered, the business has said there's complaints, I'm willing to sit down with people and see what their complaints are.
No, I appreciate that. And there's actually was further exchanges, and I actually did speak face to face with Paul, and I actually spoke face to face with him when there was when we photographed the whole neighborhood, and there was witnesses to it, in which he was outside of his bar with like 50,000 people spilling into the street and screaming, and we have photographs of that.
I'm sorry, you set up a meeting?
No, but here's the point, and this is my question, Susan, and we can go back and forth on the DL, and that's not really the point. My question was a very pointed one. I just want to know that when there's an infraction that is documented, like such as an open bar, is the procedure to go to the SLA with that information from you at the committee board level, or is that, as you said, to wait until?
What should have happened? This was a year ago. What should have happened? I was waiting for you guys to meet, and I never got a report that you had met or anything. I was waiting for you guys to meet and report back to me. Either we resolved problems or we didn't resolve problems. That's what I was waiting for.
Oh.
I'm sorry, can you clarify, when you say there's no more dancing at 199 Bowery, how do you know that?
Yeah. Well, I have to depend on the residents. The residents that complained about it, who live in the building, I said I met with them. They're not doing that anymore. I know there's other issues there which we are not involved in. But I never got another complaint that there was dancing. I believe it has stopped.
I have a concern.
I don't know to the contrary.
But I do know that they're in a legal situation with him, so I think they're not doing anything. They're dealing directly with the lawyer in the state. But my other question is this: I'm just a little confused. So I just want to understand very clearly. If the community board is aware of any actions that could be considered illegal or in violation of the stipulations, it is understanding the procedure and the protocol you're giving us. This means that we must meet with the applicant before you can report.
No, it doesn't mean that. What I said is, it depends. If I am in touch with the applicant, I am somewhat limited, as you know, by my resources. So I try and do as much as I can, and I have to prioritize. And I have to recently, I have not had the help since Dave Miller has left. I have not had the police resources that I've had either. So what I am in the situation now, it kind of depends on the situation. In this situation, there was a complaint. Often when applicants and not applicants, often if there is a complaint, I shouldn't say often, in a good situation, sometimes when there is a complaint and the business owner offers to meet with the residents, because usually if they're not responsible or they're not willing to resolve it, they don't offer to meet. So often when the business owner often offers to meet, things are often resolved, and there's no further action necessary. If I were to report every complaint in the New York
This isn't about complaints,
community
Susan.
board,
This is about a blatant violation of the law.
We'd have to hire about 50 people. I don't have that much.
This is not about a complaint.
I'm not talking about noise complaints, and we have to document that. I'm asking about
even bar. We have the worst problem in New York City. So generally, when people meet, at least some of the problems are resolved. Sometimes I do what I can. For instance, I have complaints about one place in the 9th precinct, and I did get the police to go over there and tell them they must close their doors and windows at 10. So that resolves some of the situation. I don't have that right now on the 7th, but the thing is, we agreed on a plan, and I said in writing, that I would be waiting for you to meet with them. So that was it. We had agreed on this.
I actually don't think that was a conversation, Susan. You kept every time we complained about.
It was an email.
No, every time I've got emails too. When we complained about Paul Saris, you always went to bat for him. We kept saying this is a problem. Paul, which he admitted, I said to him, you have to do something about the DL. It's a really huge issue. It's very hard to go to someone who keeps breaking the rules, and but that's neither here nor there. I'm just trying to understand procedure and protocol. So that's really what I want to get at. And I also would like to.
Necessary if you felt you need. I have met with. I prefer not to simply because of time, but if it's a serious situation, I have met with residents and a business owner to help facilitate. Like with 199 Bowery, I met with the residents, the business, and the precinct. I will try different things, but if you come back to me and said we don't want to meet alone with them, or if there was a conversation, I would have tried to make something else happen.
Okay. Well, we appreciate that. We appreciate that. I guess I'm just trying to understand exactly the procedure what's required. And I'm not saying that.
What I'm going to say is I have to prioritize, and it depends on the seriousness. It depends on whether the person is willing to try and work. So I guess I could say the procedures, if we all agree on something, which I felt that we did, then I feel like, I have to stick by my word that this is how we're doing with it. If you come back to me and say, this isn't working for us for some reason, we need to do something else, then I will try and do something else. I want to work with you.
Okay, we appreciate that. Gigi, can I just ask you one more question for clarification? We've been suspended by the community board. Is this also been? Does the New York State Liquor Authority has agreed with this as well? Or this is just coming from the community board?
We haven't discussed any of this with the SOA.
Okay, so
we have not discussed any. We wanted to speak to you first, which is why we said that I wanted to preferably meet in person. What it basically means is that for the next 3 months, of course, you guys are free to organize as individuals and residents of any of the applicants that are in, that come into that neighborhood. It's just that when the applications come in, we will not be giving them your name and contact information as a block association to reach out to sort of as a strong recommendation on our behalf.
Okay. Now, I just want to thank you for that explanation. Now, when you say that, when you say we can meet as individuals or residents, is there a rule in the charter? Can you explain that? Are we legally bound to this? Are we not allowed to assemble as a group if we choose to do so?
You are allowed to do anything. It's just a question of whether the community board is considering your position as a block association and telling the applicants that they must meet with you.
Okay, and if the applicant chooses to meet with us and recognize us as a group, is that an issue?
The applicant cannot choose to recognize you as a group because it's the referral that comes from us.
Okay, so if...
The one exception that happened without us is Russ and Daughters, because a dweller lives in their building and referred them to Emily, and I didn't want to make a fuss about it.
Actually, Russ and Daughters has actually been talking to us way before they were going on the agenda, so we've been working with them. But
and an applicant who would want to work with us and negotiate, some sort of applicants are certainly, if they are willing to, and they should, especially if their business, you have residents in the area that are in very close proximity to them, to do that on a personal level and to address concerns. It's just that you guys won't be the entity of the block association known as the L.E.S. Dwellers for, as the block association entity for these 3 months.
So but I just want to be clear.
What I was going to say is that what that means is that that you represent the group of people, but not represent that community, or the people on that block.
Okay, I just want to clarify. I'm a bit confused. I'm sorry. I guess I don't know all of the ins and outs of this and your decision. So I just want to be very clear. We won't be recognized by the community board as the L.E.S. Dwellers, and we can't represent the community of those that live on these streets that are part of our group. We have to either show up as individuals, but we cannot show up as our group. Is that correct for these next 3 months?
Correct. Yeah, and people do that all the time. You see it. So people say, we're 5 people from this block, and we feel this, and this is going to impact us in this way. It's certainly something that always happens.
Oh, okay. But if we choose not to, do we have a choice to maintain our group as we see fit? Or do we have that choice?
I'm not sure what that means.
Okay.
It's not recognized by us, and we're not telling the applicants they have to meet with you.
Okay. So it's not recognized by community, and it's not going to be recognized in the New York State Liquor Authority, or is that something that we need to
They
pursue?
don't recognize anything. This has nothing to do with them.
Okay.
And that's how each community board works depends on that community board. And the SLA, what they have said is that they want material submitted from the community board. So as individuals, if you want to send stuff to the community board and say, this is some facts, you guys do a lot of really good investigating. If you want to send some facts ahead of time to the community board to consider, you can do that just like anyone else can.
Mm-hmm.
And people do.
So we want to go back to, I do want to just have this conversation so it's very clear and so we understand exactly what occurred. So in the case that when we asked the applicant to withdraw and you asked them to be put back on the agenda in the email that we received, the following month before that, you suggested us to Shapiro's, which is directly across from that applicant. Now, do you know in this situation where we asked this applicant to withdraw, which is an applicant that should not be in this community, and it was shut down in community board 2 and what have you? Our facts are very very solid. Do you know that we are not representing the people that live in that building or next to it or behind it? I just want to know where this is coming from. Are you assuming that? Are you assuming the statement that was sent to ask for the withdrawal? I just want to ask you, Susan.
You are telling someone to withdraw from our agenda that we invited them to be put on the agenda.
Yeah, but we have a right. Do we not have a right to ask? We actually, if you read the letter, it was very kind. Our findings would suggest that this is not the right fit. We ask you to withdraw. Does a community group not have a right to ask an applicant to withdraw?
And particularly because the evidence against them is not something they wanted public, I think the worst option were to have them appear and have us expose that stuff in public.
Yeah, that's okay. The lawyer was clear about disposing this, so he doesn't want it on public record. So,
but I have all that information. And it is on public record. And now it is. I've sent it up to the
Was it when they were true?
Okay, so did we, because we wanted to make sure that his license is not able to be transferred because he's running a dummy corporation.
No, what you need to do is work with the community board and work with us. You're not working with us. You need to give us the information ahead of time. You should not be telling people that the people are required to notify the community board. And the city board then invites them to be on our agenda. If you have issues that you think the community board should be aware of, you should let the community board know, just as if I'm dealing with the SLA. I would never tell someone not to go to an SLA meeting. I would give information to the SLA.
I think we have to be careful. We didn't tell anyone not to do anything. We informed them of the information that we had and asked them to withdraw. That's a very different thing. There was no...
You asked them to withdraw from our agenda that we invited them to.
Okay, Susan, this is really... I'm going to have to just be very... okay. We gave them the option, but based on our findings, and that they don't have the community support and of the people in that building, but you didn't bother to ask that, which is very fine, and it's 100 feet from my door, is we asked them to withdraw. They had a choice to do it, and we didn't do it in a way that we gave them our findings, and they could have chosen to stay on that agenda or not. What I'm trying to ask you very clearly is, are you saying that as residents that have formed a group, we do not have the right to ask an applicant to do anything without the approval of the community board? That's my question. Are you saying we do not have a right to submit legally a document that asks them to withdraw unless we go through community board? I just want to be very. I just want to understand that.
Legally,
yes,
you can do anything you want.
Okay.
And I'm going to ask JJ to weigh in on this. I think this is a really gray area. What I would say is, if people are going through a process where they are required by law to notify the community board, which is mandated to consult with the SLA, chooses to do that by asking them to come to a public meeting, because everything we do is public. I think that, the community board is here to work with the community and work with community groups, and I think if there are issues that, for one reason or another, should prevent the community board from, from being able to have this public meeting, I should think that the first thing you would do is consult with the community board. There are times that block associations have come to us and said, this happened 2 months ago. They contacted us, 4 days before the community board meeting, and they, showed me the email, and I went to the applicant and I said, we gave you this information 3 weeks ahead of time, and you didn't contact them until a few days before the meeting. I think I would suggest that you withdraw, immediately contact the community board and get on next month's agenda, and they agreed to do that. That is why we copy you now on whenever we give someone your information. We now contact you, so you can let us know if people don't contact you in time or any of that. We're willing to, we want to work with you on all of this, but it's just a question of working together.
So, Sam, to answer your question, you are well within your right to make the recommendation as a block association that because of you guys representing that block as the L.E.S. dwellers, given the overwhelming amount of concerns that you have, that the recommendation be that they withdraw and reconsider. You're well within your right to do that. However, the reason that this is such a red flag for us is because of not the message, but the approach and in which you're delivering that message. If that was what you came to the community board with and read your concerns and said that as a block association that this was our recommendation and that this was the recommendation that we forwarded to the community board and they have all of our concerns ahead of time, then that's very different than kind of taking it on your own to do that in a way where multiple owners and attorneys have used the word, aggressive or intimidating to describe your approach. And I feel like I've sort of had this same conversation with both you and Sarah, a couple of times leading up to this conversation, that there's a larger context of both kind of what all the standards that all block associations that we work with and acknowledge and recognize are held to, and it seems to certainly myself, Alex, and Susan, as well as other block associations and sort of other players in this FLA process, that for some reason you guys aren't playing by the same rules as the other block associations are, and that there are some actions, and these are gray areas.
I will admit that you guys are taking the extra step and sort of the extra to sort of play a role that the community board should be playing, and taking it upon yourself to do that. And that's how it's coming across to a lot of people.
So the conflict I have here is at the same time, right, we're being told to work with applicants, try to negotiate things, make meetings shorter, et cetera, et cetera. The reason for sending the stuff in advance is to do exactly that, is to explain clearly what our concerns are about the place, why we don't see that there's a resolution, since, we have standards, and most of these places, or many of the places that we've opposed, don't comport with those standards or come anywhere even close, right? It's a way of being transparent to them. Now, I'm sorry that they feel that it's aggressive or intimidating, but it is in the spirit of transparency and not getting to that community board meeting, which I know that I have heard that as well, is that, it's not fair to applicants if they don't have an idea of what that opposition is in advance. So it's sort of, to me, it seems like going on both sides, right, of the same comment. So either we are very direct up front and clear about what the opposition will be, right, which is what that statement was to 125, and other statements have gone to other groups, and so they're prepared if they want to proceed. Or we withhold that information, or say quietly, late hours don't work for us, you don't comply by that, and then put everything together and come up to the community board. I don't know, it seems like no win to me. I don't see the setup for success at all.
Why didn't you convey your concerns to me, to the office? Thing. I got to tell you, and this is something I think Gigi was referring to, and it was not just SLA, it was stuff in general in her message at the board meeting. I get, like just today, I have an applicant emailing me and saying, you know, we're on the agenda, are there any complaints and concerns? And I write back, no, because as far as I'm aware, there aren't. So if you're doing this, you know, the office is the appropriate place for them to contact.
Susan, as we had at the last meeting, the things that we send into the office aren't filed properly or referred to properly. We've just seen 2 applicants renewal who should have been up, who I know I sent you complaints because you asked me to, and I actually sent it twice because I had typos in the first one, and I don't like having typos. I remember that very clearly, and so there is a breakdown in the processing system, and I appreciate that you have limited resources. You know I do too, and you know that all of our time otherwise is volunteer. So we certainly have limited resources. So if there is, maybe we need to talk about a solution about ensuring that information that we give to the community board is properly filed and will be there when we need it to be, right? Then I think we would have a little bit more faith in being able to navigate, you know, these procedures and timelines.
Okay, I will not acknowledge the lack. My office is very not perfect. Very not perfect. At the same time, I think we do an extremely good job. And to say that you're not giving us any materials because we're not 100% perfect, because there are plenty of things we have done, sat down and worked with you, and sat down and worked with other people.
Susan, I'm going to have to, I was going to try to restrain I'm just going to have to be very honest about this. The breakdown in communication that has occurred, if you want to perceive it that way, you can try to put the onus on us, but there have been cases where you have been very fickle with us, very I don't know what the word is, very upset when things didn't go the way you wanted them to go, in the sense of Soho House, when we are a volunteer group of people that must assemble information. You think that Sarah and I do all this? We don't do all this alone. There are people on the back end that never go to those meetings that are doing the research, reading our legal things for us for free. All of these things they're doing, and it takes a lot of people with their volunteer hours. And so when something can't get to you when the time that you think it should be done, you take it out on us. And we can only go as fast as we can. And then when we do that, you go and say you're not going to come to the SLA hearing. So it's a relationship.
Okay.
Yeah. So I just want to finish.
What we would do, and you did many things that was not part of the agreement. And I said to you that I felt that the community board, as I was up there to represent the community board, and that I didn't feel I could be associated with this.
Okay.
And I just want to say, regardless of, who's right or who's wrong, often very subjective, but the impact or the effect is the bottom line.
Exactly.
And the strategy, what I'm trying to say is strategy is often what makes things work or not work. Dennis Rosen did tell me, because I told him why I didn't come up, and he said that it's true when that we were talking about things like the resolution letter. First of all, lawyers have complained about the intimidation to withdraw. So I don't know how often this happens.
Susan, this is
I don't know. Okay. I don't know what places.
Okay. Well, no. For example, I want to get this on record.
It's not a good strategy for you.
Okay. For Susan, let me just very clear. When you talk on these,
it's not a good strategy.
Okay.
It doesn't work for the community board because then we get associated with it.
Okay.
And
we'll distance ourselves.
Was my concern with Soho House, and I would like us to, if possible, all be on the same page.
Well, Susan, I just want to interject here.
I absolutely do think that that I work really closely with the SLA. I work closely with the police. There's a lot of things going on that you may or may not be aware of. Where I'm trying to do the same thing as you, and
sometimes there are ways to do things and ways not to. And one of them is like those letters are just not working.
Okay.
And you may think they're right. They may be legally fine. The question is it going to further your goals? Because your goals and our goals are the same goals.
Okay, I don't disagree that we may ultimately have the same goals. We care for this community. I do not, believe that you don't care. But I will have to say very clearly, when you speak in these general terms, I cannot. They need to be factual terms. We have written one withdrawal letter, which he withdrew, and the other one we wrote to Pure, and they decided not to withdraw. So let's be factual. Only 2 letters have occurred, and they occurred.
Those are the only 2 I've seen. The only other thing I know is that some lawyers have complained. Now, maybe it was the same 2 lawyers. I don't know.
Okay, and that's very fine. So let's just get that out. The thing is, I hear what you're saying. In regards to the Soho House, if we're going to have an honest and candid conversation, when you told us to get the letters, which I think you should know how hard it is to get people to do things, and to write letters are very hard. We've been very successful at it.
No, I'm very aware of that.
And so getting 65 plus letters of immediate residence, and we also are strategic. We knew what Donald was doing. We had read his thing. We knew that his signatures were very important to his case. He used the 500 catchment issue rule that he learned from us, from Barry, which you are very well aware of. So when we realized that we could use the online petition, we did it in conjunction. It was not an extra effort because it was in conjunction with the letter drive, which when we got to the SLA 500-foot hearing, it was part of their linchpin of their argument, and we could counter it by saying we had more. So in a way that when you told us not to do something, it behooved us to do it, and it actually helped our case. So
you know what? This is not the time for us to go into.
But I'm saying, but I'm not trying to go.
I think what JG said about overall message, and overall strategy and effectiveness is something to be considered. If at another time, first of all, like I said, Dennis asked me to ask you about, so they could get on the same page. That's not saying anybody's at fault for anything, but, we all agencies need to, get everyone within the agency on the same page. So if we got that information on who said that, it would be really good. If going forward, if there are problems and there are issues, you can sit down and talk about them. Happy to do that. I don't want to make this phone call about, I said this.
No, I don't want to make that, but you asked a question why we haven't been able to communicate with you. We have to it's been very difficult, Susan, to communicate, because when we don't subscribe to what you think we should do, that we get punished for it. So it's a situation.
There's nothing I can do about.
So, but let's.
Okay, so here's what I see moving forward, and again, we can agree to disagree on a lot of things. What I will say is that I do not believe that Susan is holding you guys to any higher of a standard than the other block associations. Do you guys have more contentious addresses and applicants and owners? I mean, looking at the last couple of months, yes. Do you have, which does that require more work and more effort? Yes, but to me, as board chair, I have to look at what's best for not only my board office staff, but for the board overall and our accountability. And so, and while David McWater and I have disagreed on many, many things and got into many bitter fights over them, there is something that he said that really I agree with him on, is that despite your wins along the way, which they're huge. 106 was huge. Soho House was huge, right? And yes, you are getting wins along the way, but you are also alienating people who have a role in the process and are supposed to be helping you and working with you. Mm-hmm. And you're not going to be sustainable as a group over time if both the community board and the SLA do not feel like you guys are doing your work in the right way. And I think, okay. and I really urge you guys to think about that, because Susan, myself, and the State Liquor Authority, we have to know and trust that the work that you're doing continues to hold water and is is reputable, and in order for us to support you guys when you come before us at board meetings and when you go up to Albany, because in some ways, the way I see it from the outside is you guys are sort of working against yourself in the long run, despite having victories on the ground.
Okay, we appreciate your analysis but I think we have a long game, but that's okay. We appreciate that analysis, but I do have to just ask you a question. Was this decision voted on to remove us for the 3 months, or was this made between you, Alex, the New York State Liquor Authority, and Susan? I just want to be clear.
So the SLA, again, has nothing to do with this.
Okay, so
we're just telling you that was part of what I considered in making my decision. So for the record, this was not voted on.
Mm-hmm.
This was a decision that was made between myself, Susan, and Alex,
mm-hmm.
and we discussed it. We discussed it at the last executive committee, and we gave our rationale. So there were 10 members there of the executive committee that were there and had this discussion. But at the end of the day, the decision does rest with me, and so that's. I mean, does that answer your question?
Yeah. I just want to know if this was voted on, so that you clearly explained that. I appreciate that. Okay, Sarah, did you want to add anything? Okay, we hear what you have to say. We understand. I just want to I want to be very clear. There was one little comment that you made saying that we are alienating other community groups as well. Can you explain that? That our approach seems. You said that there's a bunch of. Okay, we know the lawyers don't like us. We know the applicants find us this way. We know members of the community board. Can you explain? Other community groups have come to you as well, complaining about our approach. Can you explain that, Susan?
There are other community board members.
No, community groups, other community groups. I'm not community board members.
There are other community board members that are part of other block associations,
mm-hmm.
Who feel like, and I don't want to speak for them, but when we had this conversation, their concern was that you guys are there and turning down every, recommending that denial for everyone, which is not based true. Based on your standards, and based on the applicant, whatever is the specifics, may not meet your threshold, right? And that's fine. And it's not about that. It's just about the way in which the information is presented, and it just comes across as, I'm not sure if distasteful is the word that I want to use,
mm-hmm.
but you guys are becoming very much looked upon like you're I don't know what I'm not being articulate. Sorry.
That's okay. It's okay. Take your time.
I mean, I don't want you to think that. I don't want you to think that I took this decision lightly. You may not feel this way, but I feel like in the previous conversations that we have had, I hinted that if this was not going to kind of turn around, that I would be forced to make a decision like this. And it's really my hope that you guys will reapply in 3 months, and that things will change. In terms of... So
you're saying our applications are now suspended and we would have to reapply in 3 months. So what we have on file with Susan we'll need to reapply.
How do you want to handle it? Do you want to automatically...
We still have all the information. I would think that an email that you would like to reactivate, JJ, if you think it's okay, I would think that would do it.
Mm-hmm.
Okay, so unless there's any substantial change in your structure, in your organizational structure as a block association, barring that, if you just send an email in 3 months, and since we stopped referring for October. Is that right, Susan?
Yes, so then, and Daughters is the only one. Other people
October, if we don't refer for October, November, and December. So I would say email us after the December SLA meeting.
This is if we.
January, like the middle of December.
Okay, so but and what are the ramifications?
Representing our area now.
So we want to be very clear about that. So there's no block association representing this area. Is that correct?
Could there be a block association that applies this month to represent our area?
We've already told people that everyone's already contacted us, and we've already told them.
No, I'm asking about residents.
Pardon?
I'm asking about residents.
Have you informed them there's no? Have you
association in place as a vacuum?
No, I want to know if you informed the community that L.E.S. dwellers have been suspended and that they will no longer represent this community for 3 months. I want to know if that's been.
I have not done that.
Okay.
I have not done that.
We have done
First and foremost, I have not done that. And I don't want to make this a PR thing or a big, brouhaha kind of upset. That was not my intention. What we have done is that when the applications come in and they fall within the boundaries in which you currently do represent, we have said there's currently no block association that represents that area.
Okay, that's very okay. I just want to understand that logic, Gigi. I understand that you've informed the applicants of that, and you've explained there's no block association. But of all the members that we make up and the people that we represent and have taken actions, don't you think they should be informed that you will no longer allow applicants to be referred to anyone? I think that should be. This is about the community. I'm a little concerned that you may have informed the applicants, but doesn't it behoove this community for the residents to know that this block association will not be in existence for will be suspended for 3 months? I'm just trying to understand.
Sure. So part of the reason I haven't done that is because I wanted to talk to the two of you first. So I am happy to discuss how you think that should happen.
Well, we're basing it on that.
Write an email to you guys on the record as what would be helpful?
So, but you're saying that you're
I think we need to.
We can't tell you what's helpful. We need to bring this to the community and have a vote to our group. This needs to be discussed if we are going to concur with these terms, or if this doesn't rest on Sarah and I. This has got to be a community effort in which they vote on it, as we've done.
Let me just say one thing. When we say there's not currently a block association, we say gather petition signatures, and they have to go gather petitions, so they should be out on the street. They still have to put up the sign, that kind of thing.
No, we understand. We understand what the applicants. We understand what the applicant has to do. We're saying to you, we cannot make this decision right now, unilateral decision between Sarah and I, saying that okay, this is what you should do. We just think this has to go to the group, and we need to let this information out. We believe in transparency. We need to see what should be done. Like if we agree to these terms or not, and do we feel if this is just, and we feel and. So, I think that's democracy. I think we have to do that. I don't think I could say, okay, we'll take the suspension and not let anyone know about it. I think that it wouldn't be fair to all the people that volunteered and worked really hard. So that's...
I think that's fair. So what I will do is I will draft something and I will send it to you over email. If you'd like, I could have put it on official letterhead and have it be sent to you. But I wanted to have the conversation with you two first, so that you didn't just see the letter or the email, and I will that will be out no later than end of business on Monday. Okay. My question that I really want to know is in the period that we're suspended, according to the community board, if someone applies for a block association on my block day, how will that application be assessed? We're suspended, so we still cover the area, or in 3 months, if someone else, wants to form a block association in that same area, we'll be out of luck. 3 months, the Lower East Side dwellers can resume existence as an entity, if that's what you guys want. If you guys decide that you separately want to be 5 separate block associations, you can do that too. That's up to you guys and your members and the residents. So in these 3 months, you guys can still do everything you do, but as individual residents on the block, as a group of concerned residents, but and still testify at the SLA committee hearings, but not as the entity of L.E.S.
No, I just want to be very clear, Gigi. You're saying if I show up next Monday in October and I say I'm L.E.S. dwellers, I cannot do that?
I mean, listen, you can. I can't impede your freedom of speech, but then Alex will be forced to say, for the record,
we are not recognized.
The community board does not currently recognize the Lower East Side dwellers as a block association, and she'll have to do that.
Okay, that's fine. I just want to make sure that that we understand that. Should we proceed as a group in the same formation that we have, the ramifications of that would be that you will, at every community board, state for record that you do not recognize us. Is that correct? Until the suspension or whatever happens is over, right?
Correct.
Okay. All right. And okay. Okay. I think that makes, so as we said, we have to just discuss this with the group, and we'll, I guess as you said, we'll receive something on Monday, and we'll review that as well. We hear what you have to say. I guess they're very general terms, but I guess the takeaway I'm getting is that we're seen as this group that is one issue that doesn't want to work with anybody, that is, and we're not in the long run, we're not going to be effective. Is that the gist of what this conversation is? That our approach is alienating, and that we are not working with the community board, and that we're not going to be able to sustain our group and really be effective. Is that what you're trying to like?
I guess if there was one takeaway message to take out of all of this, is that we would be all stronger working together and all being on the same page than not. And I feel like, and I will speak for the board, I feel like we've been put in a position where we can't work with you effectively to achieve what we want to achieve right now.
And can you give us a very concrete, tangible example of where we did not share with the board very important information that, for example, of 106, who did all that research? I want to know in cases where you think, and I just want to state for the very record so that you're aware of this and it's on record, that we went to the SLA with the DL because the information was not getting from the community board to the SLA about open bars, dancing, any of those things. So and about the renewal, we sat on that because we were very shocked about that. And so we had to do our due diligence on that and to find out when the date, the timing of all of these things. So those are very specific things, but I would like to know where Susan can give me an example where we did not work with you, where it was adversary, that we did not give you information that you should have had, or I would like to have an example if you don't mind, just so we can understand.
I will include that in my correspondence so that you have it for the record.
Of very concrete examples. Okay.
I hear you. No,
Okay.
and it's a fair request.
So I'd like that in written form of examples. And if Susan can add, would like to.
I have to go. I have someone come in the office I've got to meet with now. Okay. So,
Yeah, and I actually have to. I have to.
Let's touch base after you guys get the letter.
Yep, and yes, and we'll talk to the group. So, okay. All right. Thank you very much.
All right.
Bye-bye.
Thanks. Bye.